From the PEP Radio Newsroom, this is the Hourly News Blast. Trib Live is reporting that the Pennsylvania Supreme Court on Tuesday ruled in favor of a Crawford County school district in finding posts made by its board members, including those about district issues on their personal social media pages, are not automatically subject to the state's open records laws. Had the decision gone the other way, it could have made a huge impact on what constitutes public records in Pennsylvania. But since it didn't, said Melissa Melewsky, media law counsel for the Pennsylvania News Media Association, the situation remains status quo. I don't think this issue is settled for the purposes of Pennsylvania law, Melewsky told Trib Live Wednesday. They missed that opportunity here. There will be more litigation as a result. Jordan Schubert, the attorney who represented the Penncrest School District at oral argument, praised the decision. The right to know law was not meant to cross into a public figure's personal life, he said. I think it would have opened Pandora's box. He said it's hard enough as a public official today to keep any semblance of a private life. At issue before the court was a request by a man in Sagertown for Facebook posts made by members of the Penncrest School District. In May 2021, a high school library in Penncrest, which is approximately 5 to 6 miles north of PEP Radio and about 100 miles north of Pittsburgh, displayed several books addressing LGBTQ+ issues in anticipation of Pride Month in June. A visitor posted a picture of the display on Facebook with negative comments about the books, and within a few hours, at least 3 members reposted the comments and promised an investigation. This is on display at Maplewood High School. Besides the point of being totally evil, this is not what we need to be teaching kids, wrote school board member David Valesky. They aren't at school to be brainwashed into thinking homosexuality is okay. It's actually being promoted to the point where it's even cool. Except David Valesky wouldn't know the slightest thing about being cool because he never has been, and he's very sad about that. The issue was debated extensively at several school board meetings, and in January 2023, the district still had no clue what they were doing, but they revised their policies on books with what they called sexualized content. They banned 13 books, including To Kill a Mockingbird, which was recently just overturned in the state of Florida. You see, because Florida had the same goddamn law, but a federal judge had the brains to realize that To Kill a Mockingbird doesn't belong on a banned book list. The other book the district decided to ban was Beyond Magenta, Transgender Teens Speak Out. And you know what? They're going to be speaking out at the polls in November, and I hope you're ready. As the debate unfolded, Thomas Cagle, a retired government employee, filed a request with the district under the state's right to know law, seeking comments related to homosexuality school curriculum and other topics that were contained in emails and Facebook accounts for Valesky and board member Luigi DiFrancesco. The district rejected the request, claiming the posts were not official district records because they'd been made on the board members' personal social media accounts. The Pennsylvania Office of Open Records overturned that decision, finding Cagle was entitled to them, and Crawford County Common Pleas Court agreed. However, Pennsylvania's Commonwealth Court said the lower court was wrong and created its own test on how to determine whether the Facebook posts were records accessible under the law. That test, the Intermediate Appellate Court wrote, should ask, does a social media account have the trappings of an official agency account? Do the posts show activity of an agency? And were the materials created or received by the public official in their official capacity? When it deals with library books that are appearing in the schools, you're goddamn right they do! Goofy motherfuckers! Cagle appealed to the Supreme Court, which heard arguments on the issue in October. At that argument, Cagle's son, Brian, an attorney, told the justices the new test created by the Commonwealth Court undermines Pennsylvania's right to know law. It damn well does. But the state Supreme Court in its decision disagreed. The majority said the Commonwealth Court decision did not actually create a new test. Yes, it most certainly did. In our view, the Commonwealth Court did not adopt a social media specific test, and to the extent the lower court's analysis can be interpreted as such, we reject that notion, because they're bigots too. Justice Sally Updike Mundy wrote for the majority. In fact, we find little about the Intermediate Court's analysis new, because you don't know a goddamn thing about social media, do you, Pennsylvania Supreme Court? Since many of the factors articulated in its opinion have been considered in various other RTKL cases involving other types of information. The Pennsylvania Supreme Court, in its goddamn infinite wisdom, went on to say the common pleas judge who originally heard Cagle's case failed to consider several factors necessary to determine if the posts were the activity of an agency. They were the activity of one of the members of the agency. And as far as I'm concerned, that's good enough. Now, said Schubert, the attorney for Penncrest, they will return to the trial court to analyze the records at issue. Melewsky said she interprets the court's decision to take the Commonwealth Court's factors as guidance in that analysis. With social media, it's not a list of exhaustive factors, but things you can consider, she said. The decision does not block the public from accessing these records, Melewsky said. The right to know law has always reached social media content by public officials, and it continues to reach social media content by public officials, she said. Because the board members were discussing these issues on private pages, the law isn't clear-cut, Melewsky said. The devil's going to be in the details, she said. It could have been worse. Joshua Bond, an attorney who regularly argues open records cases, followed the Penncrest matter closely. He believes the court's decision will decrease public access to elected officials' electronic communications, and it's also going to decrease the public's understanding of and belief and acceptance of and trust in their local elected officials. Most people will believe that local public elected officials are screwing up. And they're going to believe that because they don't have access to the records that these public officials are sharing. They're writing emails, writing social media posts to impact public opinion, Bond said. If they're doing that, that should be a public record, and you're damn right. They shouldn't be allowed to do that in secret. And you know what? That is the News Blast at this hour. If you are watching our News Blasts on YouTube, thank you, and please subscribe to our channel. Up next, we have the Pennsylvania area weather forecast for the goddamn city of Meadville here on PEP Radio.